The key to liability on a negotiable instrument is who signed, right? Whose signature is on it is going to determine whose liability happens when. So that's what we're going to talk about next, liabilities and warranties. And let's start with the signature liability. So the key is whose signature. Generally, every party or an agent, if somebody has signed on the party's behalf, who has the authority to bind that person, who signs a negotiable instrument is either going to be primarily or secondarily liable for payment when due. There's the one exception, we talked about it, the qualified endorser. Remember that individual? That's the individual who writes without recourse on the back of the check, basically disclaiming any liability. But if you don't have that, this is how we determine liability. So primarily liable, what does that mean? That the person is absolutely required to pay on the instrument, subject to certain defenses. But who is primarily liable? It's going to be absolutely required if you are the primary one, and that is our makers and our acceptors, i.e. the drawee in most cases. They're both legally responsible. They're primarily liable. It's an unconditional liability and is immediate. It happens immediately when the instrument is signed or issued, and it's effective when it becomes due. So a maker is an unconditional promise. The maker makes an unconditional promise to pay the note when it becomes due, right? That's the person who is signing it. Do I have my, there we go, right? So Mike Maker is making an unconditional promise to pay the note when it becomes due. So when it becomes due, he's liable. He's primarily liable, nobody else. And who's his obligation to? Right, the payee or the bearer, if it's a bearer, but the person entitled to enforce the note or to the endorser of that paid note, that's who it's going to, that's the one who the obligation is made to. And then we have our acceptor. The drawee on the bank indicates acceptance by signing. Remember, here when they've accepted. By signing and accepting, they agree that they're going to pay the check when it's presented on payment. Also here, even without the acceptance, when we have the drawee, or whenever there's a presentment of a check or a draft presented on the appropriate date, the bank is the one who's primarily responsible for paying that. Now you might be saying, well, what if there's not enough funds? Well, we'll get there. But when I write out a check to you for payment, I don't anticipate you're going to turn around and give me back the check. No, you're going to take it to the bank. And so the bank's the one who's primarily responsible for paying it. Before we switch to secondary liability, I just want to present two more examples relative to primary liability. I already gave you the one that you prepare and sign a check to me on today's date, and it's with a check, it's due on demand. I bring it to the bank to cash it, and who's liable? The bank. The bank has to pay right then and there. We'll talk about if there's a problem with the insufficient funds. How about you provide me with a cashier's check for $1,000 for a car you bought from me? I bring that cashier's check to the bank. Who's liable? The bank. The bank's the one that issued it, and that's actually a form of the acceptor, very similar to the draft. You make a promissory note to me, due 30 days from now. 30 days from now, I demand payment from you. You are liable to pay that to me, okay? The maker or the drawee/acceptor. So now we'll turn to secondary liability. And what happens if the primary doesn't pay? That's going to be conditional. So this liability, secondary liability, is conditional. And this is for drawers and endorsers. They have secondary liability. So we're talking about drafts and checks, or those who may have endorsed. So endorser's second liability does not arise until the maker, who's the primary liable, defaults on the instrument. So if that note from Mike Maker was transferred to somebody else, and that somebody else seeks payment from Mike the Maker, and Mike the Maker doesn't pay the person who did the endorsing, is going to become secondary liable. In the case of the drafts, a drawer's secondary liability does not arise until the drawee fails to pay or accept the instrument. So this is where you prepare and sign a check to me, and it's dated today. It's due on demand. You go to the bank. All right, I go to the bank, and they don't pay it because they say there's insufficient funds. Who's secondary liable? You are. So the bank is first. There's insufficient funds. The bank refuses it. Now I can come back to you. Same example as above. If the second one, you make a promissory note to me that's due in 30 days. 30 days from now, I demand payment from you. You are the only one who promised to pay, so you are the one that has to pay. The difference between primary liability and secondary liability. Now, had I transferred my note to Joe, and Joe comes to you for payment, and you don't pay, Joe can come back on me as secondary liability. Same as above. Oh, I guess I just jumped the gun a little bit and did the same as above example. So if a week later, after you give me the note, I negotiate it to a third party, I'm the one who has endorsed, and maybe I just signed my name, so it's a blank endorsement, and Joe can continue to pass that along. And each person who has signed, unless you sign without recourse, is going to be on the hook, secondary liability, as the maker of the note. So what conditions? I said it was conditional. On what conditions? The instrument was properly and timely presented. The instrument has to be dishonored. And there's timely notice to dishonor given to the person who's secondary, with secondary liability. So what's presentment? The holder, the entitled holder, the one holding the instrument, demands payment from the appropriate party. And that's going to depend on what the instrument is. Obviously, if it's a note or CD, it's going to be presented to the maker, Mike the maker, on that one note we had. If it's a draft, it's going to be the drawee for acceptance or for payment, or for both. They could have been the one where you demand payment and they've already accepted. And for a check, the presentment of a check, that's the drawee bank or financial institution. It has to be properly made, and it's properly made if it's done by a commercially reasonable means, meaning that's how it's received, which could be through a clearinghouse procedure. Let's say you put it in your bank and then it goes to another bank, or you do a ATM deposit with it. It's properly made, okay? Or if the instrument says how to do it, you have to do it where the instrument says how to do it. If it's a note, it may say where you have to present it. And it has to be done timely. So failure to do so might cause the person with secondary liability not to have any liability. So what's timeliness? On or before the due date. Demand within a reasonable time. If it's a demand, maybe you're presenting a check and it has to be presented, that not to say that 6 month row. Sometimes checks will become stale after a period of 6 months. So sometimes checks have a time limit on it, even though they're on demand. It may say, but after a such and such time. I think usually the language on the check is that it's void, but that's not the case. If you present an old check, it's just subject to be rejected. So, like I said, checks may say, and then sometimes it says 90 days, sometimes it says 6 months. And in my question here, does that make it void? No, it doesn't make it void. It just might be, one, it might not be accepted, or two, the person with secondary liability might not have liability. Dishonored, we know what that is, when the required acceptance or payment is refused or cannot be obtained within the prescribed times, like insufficient funds, maybe no signature is a reason for dishonor, and they need proper notice. So to accept a draft on a non-bank or an endorsement on a non-drawer, there has to be some notice. I mean, when you present dishonor, when you present a check or a document draft to a bank, the bank is automatic notice, because that's the financial institution that your check is drawn from. Normally they're going to notify the person, but let's say it's a note mic maker to, Pete the payee. Like, these are folks that are non-financial institution in my example, and that happens, the transfer of these notes. So if you're not a non-bank, you're going to have to give notice. The common practice is once it's dishonored, the holder must give notice to those who are secondarily liable on the instrument. Of course, it's dishonest. If it's dishonored, the first thing you're going to do is go back to the person that you got it from. But notice has to be given in a reasonable manner. Could be done orally, written, or email, whichever is reasonable. So for example, do I have it here? Yes, Omar writes a check on his account to State Bank payable to Lee. And then Lee endorses the check in blank, meaning she just signs it, and cashes it at Midway Grocery. Some grocery stores cash checks, which then transfers it to State Bank for payment. Okay, so my first question is, who is Omar? Omar is the drawer on the check. State Bank, that's his bank. That's the drawee. That's the one that you have to be presenting it to for payment. Who is Lee? Lee's the payee. She's also called a holder. She's holding a negotiable instrument. And what did she do? She endorsed it in blank, meaning she just signed it. There's no restrictions on it, so technically she can pass it to whoever she wants to at this point. And she gives it to Midway Grocer here to cash it. So the question is Midway Grocer a holder in due course? Meaning, does it fit the description of written, value, good faith, no notice, without notice, good faith, and no notice of any sort of problem with the authenticity of the document? I would say Midway is the holder in due course. What's the value? They cash the check, right? They give out cash, and she gets the cash, they get the check. They're going to forward the check to State Bank. So who is primarily liable? That would be State Bank. And State Bank now says, oops, there's insufficient funds. So they dishonor the check. So who would be secondarily liable in this case? Lee would be secondarily liable. So Midway would have to give notice to Lee. What must Midway do? Give notice to her. What if Lee wrote without recourse and signed it, disclaimed any liability as a qualified endorser? It might give her some leeway, but Midway Grocery probably wouldn't have taken it if that's what happened. And we haven't gotten to the rights that are available yet to our holder in due course, but they will not. Just on a side note, we'll pick it up in a little bit. In this instance, because Midway is a holder in due course, they would actually get payment from State Bank. State Bank would have to go back to Omar. But just taking this down the lines of secondary liability and primary liability, that's how this example would go. And I'll double back to it when we hit the liabilities or the rights, the higher rights that a holder in due course has against any defenses and such. We're back to Bob selling his bushel of apples to Nora for $5. Nora pays with a check. 2 days later, Bob buys some oranges from Pat for $5, and instead of paying cash, Bob endorses to Pat Nora's check for $5. Can he do that? We've talked about this already. He sure can. How does he do it? By endorsing the back. When Pat demands the money from Nora's bank, it refuses because Nora stopped payment because the apples are rotten. The question is, who is primarily liable? Well, that's Nora's bank. Who's secondary liable here? Bob, because Bob endorsed the check. The question is Pat a holder in due course? Yes, he meets the requirements, and he may, or the bank has refused, but his rights and liabilities will be a little different, and we're going to be switching to that after the next topic when we talk about warranties and defenses. This is for the sake, as I'm taking Bob and Nora through this section of negotiable instruments, we're kind of doing it step by step of how all that plays in, and this is just an example of how the secondary primarily liabilities work when you're passing the check. Certainly things are slightly different for our holder in due course, and we're going to get there in a second. So then we have unauthorized signatures. What happens when we have unauthorized signatures? Well, they arise in two ways. Either by forgery, right? Nobody said you could sign my name. And when an agent acts without authority. Generally, unauthorized signature is wholly inoperative and will not bind the person whose name is signed or forged, but there are some exceptions to that. And we talked about the first one when we talked about agency law, and that's when our principal ratifies the signature, right? Ratification. And the other time is when the negligence of the person whose name was forged contributed to the forgery. So what I mean by that, that's my example here. So what do I mean by when the negligence of the person whose name was forged contributed to the forgery? For example, sorry, I clicked the slide. So not on this particular slide yet. I just want to give you the example of the negligent person. So you write out a check for cash and you sign it, but you don't put the amount in, and you just kind of leave the check around. And then a classmate finds it, writes the amount in, and cashes it. You may not escape any liability if that is dishonored because you contributed to the negligence by leaving a check around and leaving it almost blank, the most important part, the money, right? But generally, the person who is liable for an unauthorized signed negotiable instrument is the forger. The one who did the forging will be liable. Now we'll switch to unauthorized endorsements. We just did signatures. That's the signature of the maker or the drawer. We're talking about endorsements now. The one who's doing the transfer of the document. You've been given the document. Maybe you gave me the check. By me signing it, I'm endorsing it, and anyone subsequent to me would be an endorser. So the question becomes, what happens in that instance? Generally, any forged instrument doesn't transfer title, meaning it's no good, it's void. But there are some exceptions. There's always exceptions to these rules, right? When an endorsement is forged or unauthorized, the burden, and in those two exceptions we're going to talk about, when the endorsement is forged or unauthorized, the burden of loss is going to be on the first party to take the instrument with the unauthorized endorsement. Okay, there's two exceptions to that. Why that rule? Because the first party to take the instrument is in the best position to prevent the loss. So let's talk about James here. James gives Lauren a check for $200 for a debt that's owed. Lauren loses the check. Gloria finds it, endorses it with Lauren's name, and presents it. Is that gonna fly? No, that won't. That won't transfer title. That's a forged endorsement right on its face. What if Gloria transferred it to Steve to pay her own debt, and then Steve presents it? Same thing. It's a forged endorsement. Doesn't transfer title. It's not going to continue down the path. But two exceptions. When we have an imposter and we have a fictitious payee. Those are our two exceptions where the person doing the endorsement may be held liable. So let's talk about imposter. So who's an imposter? We all know what the imposter is. It's a person with intent. They have to have intent to deceive. They pretend to be another person, or they may pretend to be that person's agent. Okay? So if a maker or a drawer, we'll do this example in a second. So a maker or a drawer issues a note or a draft to someone they think is the payee. And the imposter then, in turn, signs the payee's name. Basically, effectively negotiates this now or to a subsequent holder, that subsequent holder can collect from maker of the drawer. So let me use this example. So James owes Lauren, who he has not met, $2,000. Gloria, claiming to be Lauren, gets James to issue her a check for $2,000. Gloria forges Lauren's endorsement and transfers the check to Paul, who knows nothing about what's happened here. The question is, can Paul collect from James? And the answer is yes. Why? Because James here is in the position to avoid this loss, right? What's the difference here? He was induced to create the negotiable instrument, right? He created it. And he bears the loss because he failed to detect the scam. James intended the imposter to receive the instrument. He may have thought it was Lauren, but he created it and made the instrument. So that's how the imposter rule works. Then we have our next exception, the fictitious payee. And our fictitious payee is a payee on a negotiable instrument whom the maker or drawer does not intend to have an interest in the instrument. And this usually happens on two situations. We have a dishonest employee who deceives the employer into signing an instrument payable to a party with no right to receive the instrument. Or we have an employee/agent who has authority to issue an instrument and issues a check or an instrument to a person who has no interest in the instrument. And the question is, can an employer be held liable to the innocent holder? And the answer is yes. A payee's endorsement is valid, and an employer can be held liable on the instrument to the innocent holder. So Stewart submits a time card, for example, submits a time card for a non-existent employee, and the employer issues the payroll check. Stewart forges the endorsement of non-existent employee and transfers it to Reed. And the question is, can Reed collect from the employer? Yes, because the employer is in the best position to be able to figure out what the scam is. They're the ones who are responsible. Now we talk about warranties. Remember warranties? We talked about that in sale of goods. Kind of similar regarding warranties here, where a transferor makes certain implied warranties when doing transfers. So they can when their implied warranty is in regards to the actual instrument itself that they're negotiating, okay? And this usually arises when the transferor does not endorse the instrument, or there's a qualified signature on it without recourse. So when you have a without recourse, or you do not have an endorsement, certain implied warranties arise, and that happens in two situations. We have transfer warranties. That's when it's being negotiated to be transferred. And then we have presentment warranties. And this is when the person who is holding the negotiable instrument is presenting it for payment. So generally, let's go here. Transfer warranties. Generally, it's a guarantee made by any person who transfers a negotiable instrument for consideration to all subsequent transferees and holders who take the negotiable instrument in good faith. Meaning, note, this is no gifts, no inheritance. We got to make it's something for consideration, maybe cash for a note, however the arrangement's going to be. But there are 5 warranties. And remember, they're not endorsing. There's no endorsed signature, or it's a qualified endorsement where they're saying they're disclaiming liabilities. They're actually going to have some warranties. So the first thing they warrant is that the transferor is entitled, well, I think I have them here. Yes, there they are. The transferor is entitled to enforce the instrument. If, like I said, and basically that means that they can if they weren't transferring this negotiable instrument to another, they would be going to collect on it. So basically they're saying they have good title. Okay, so they're the ones entitled to enforce this negotiable instrument. That's the first thing they say. Warrant, that's the first thing they warrant. And the second thing they warrant is that all the signatures are authentic and authorized, meaning when I say signatures on the front and any subsequent endorsements or any prior endorsements. And that the instrument has not been material altered in any way. That the instrument is not subject to any defense or claim of any party that can be asserted. And there's no knowledge of insolvency, basically a bankruptcy proceeding against the maker or acceptor or drawer, the person that they have to collect on. So there's no insolvency proceeding. But I do note that after saying all of those things and there's these warranties, the transferor can ultimately at the end disclaim these warranties in any instrument except a check, because a check is for payment. But in any instrument that they're transferring, they can ultimately express that they are disclaiming all of these warranties. But they're there. Nonetheless, you should know about them, even though they can be disclaimed. So, for example, we got Wiley forges Kim's name as a maker on a promissory note. Basically, he creates a promissory note and he signs Kim's name to it. The note is made payable to Wiley, and Wiley endorses the note in blank. Okay, and remember, by doing that, it becomes a bearer instrument, and anybody holding it can cash in on it. So then Wiley negotiates it to Brett, and we'll say Brett's a holder in due course. He meets the requirements as a holder in due course. And then Wiley leaves the country. So now Brett has this note that's been endorsed in blank by Wiley, which is certainly transferable, and he can cash it in at any time. But Brett, without his endorsement, he delivers the note to Fern, which he can do. He can just, because it's good. It's like a bearer note, right? It's good as cash when you just sign it in blank. And then Fern, in turn, without endorsement, delivers the note to Rick. And then Rick presents the note to Kim to get paid. And Kim, that's when we discover it's the forgery. So the question is, can Rick hold Fern, who's the immediate transferor, liable for breach of warranty that all the signatures are genuine? Yes, he can. Can he hold Brett liable? No, he cannot hold liable. However, because Brett is not Rick's immediate transferor, the reason why he can is because Brett's not Rick's immediate transfer and did not endorse the note. If we had an endorsement, then we have something different. But in this instance, we don't have an endorsement. This is a bearer instrument, and it came all the way down the line. So the only person that Rick has any recourse to is Fern. Hopefully that makes sense. If it doesn't, shoot me an email and I'll do another example or kind of re-listen through that again. And as I said before, they can disclaim these warranties. And then there's presentment warranties. It's a warranty made by any person who presents an instrument for payment or acceptance. And we're usually dealing with a draft in this case. Who's it made to protect? The person whom the instrument is presented, right? And again, these warranties can be disclaimed as well. So it's any person who obtains payment or acceptance of an instrument. They make the following warranties to any other person who in good faith pays or accepts the instruments. So they claim that there are no missing or unauthorized endorsements, that the person obtaining payment or acceptance is entitled to enforcement of the draft, that there's no alterations, and no knowledge that the signature of the drawer or the drawer of the draft has been unauthorized. So basically that it hasn't been messed with in any way, and that they're the person who's entitled. So that's not forged. They're saying it's not forged or not messed with. And if in fact it ultimately learns that it is forgery, then the person making the forgery is going to be liable for breach of warranty to the bank, to the financial institution, because that's who you're presenting your draft or your check from. So can they be disclaimed? Yes, they can.